Petitioner, like the defendant in Carter, was not informed of a mandatory parole term to be served after the completion of his confinement, neither at the time the court accepted his guilty plea or at sentencing. Therefore, based upon one, failure of the court to inform the petitioner of his mandatory parole term, as stated above, the mandatory parole term as a direct consequence of the petitioner's guilty plea, and three, petitioner's guilty plea, which was not voluntary, intelligent. Petitioner's due rights have been violated. Given the process violation, the petitioner is entitled to immediate release, and that he was already been confined for a period of counting probation, 8 months, 18 months in prison, and 4.5 months of parole, which comes to about a total of 28 months on a 16-month sentence, which easily exceeds the sentence for which he bargained, as the court stated in Carter in discussing the remedy of the defendants therein. There remains a matter of remedy in Santabello versus New York. The court held that where a petitioner has relied on a promise by the state in a plea agreement which has not been fulfilled, either withdrawal of the plea or specific performance of the agreement may be an appropriate remedy. Since the defendant has already served a sentence well in excess of the one which he bargained, leave to withdraw his plea would clearly be of no benefit to him. The district court was correct in addressing that the defendant be released from any further service under parole term. Emphasis added 806 F2D at page 1377. Now, I filed a petition in California courts. This is after the petition has been filed. The court must endorse upon the petition the hour and date of its filing and act on it without delay. California Rule of Court 260 requires that a court act on a petition with 30 days of its filing. The court may deny the petition outright, but must state its reason for doing so. If the petition is not denied outright, the court must issue a writ of order to the respondent custodian to show cause why the release should not be granted. Along with the order, the court will send to the Attorney General a copy of the petition filed with the court. The Attorney General must be given at least 24 hours to file a return, though the usual practice is to give 30 days. Return is a legal document that explains why the authorities believe the petition should not be given the relief requested. Any allegation in the petition not converted in the return shall be deemed true. Got it. Okay.
You can
January 22nd, 1990. On my petition for writ of habeas corpus, Mark Muncy versus the Department of Corrections responded. An order to show cause was issued to the Attorney General's office and the Department of Corrections. It says, the respondent shall show cause by return filed in this court within 30 days after the date of filing of this order, why relief sought in the petitioner's file herein should not be granted. Within 30 days after service or filing of the return, the petitioner may serve on the respondent a file a transverse. Failure to file a transverse may be deemed by the court to be an admission of the allegations of the return. A copy of this was sent to Marvin Link, Deputy Attorney General, Department of Justice, Office of the Attorney General, 455 Golden Gate Avenue, San Francisco, California, as a respondent. 60 days after the respondent didn't act, I talked to the Deputy District Attorney and got a court date that stated I was supposed to get off of parole because I had served my sentence already. So on court day, I got handed my petition, my response to the petition, but not by the Attorney General's office, but by the District Attorney's office of Delaware County. And it states here, after considerable research, the people have concluded that there is a split in authority concerning claim made by petitioner herein. Henry Cambria, 5th District, 1983, is in agreement with petitioner's posture. Enrica Bliss, 1st District, Division 1, 1981, is contrary to the petitioner's contention, which petitioner can't answer that because there is no titles. And also Allen versus Bonnell, 1989 Daily Journal, 1460-91 cites Carter versus McCarthy, 9th Circuit, 1986, page 806, F2D 1373, as controlling law in that district. Carter stands for the proposition that failure to advise a defendant of parole conditions makes the imposition of such conditions improper. The people therefore submit the matter. This was handed to me in court in Delaware County, and my writ was denied based on Reich and Bliss. The petition for writ of habeas corpus is denied by this court. There went out my order so I can write a transverse or return to any allegations on my petition. And under Allen versus Bonnell, it does not state that the imposition of parole is improper, but states that this court holds that a defendant is not informed of a mandatory parole requirement, then the maximum time in custody plus the parole status cannot exceed the length of the actual sentence imposed. But since the research didn't see this, I served additional time in prison, and I'm still on the run on parole as of this day. Now we're up to December 20th of 1990. In the matter of an application for Mark Muncy for a writ of habeas corpus. This is another application I've put in since my last incarceration. This matter is transferred to the Superior Court of Delaware County. The court finds that to be appropriate jurisdiction for the above-mentioned writ, and that the circumstances upon this writ is based out of Delaware County. Griggs versus Superior Court by Michael Brown, Judge Michael Brown of Humboldt County. This writ is sitting in the Delaware County courthouse right now. It's been there for 5 months. So under Court Rule 260, the California rules, Court of Rules, under habeas corpus, that was already violated. Judge Robert Ware stated on August 23rd, when my writ when it was denied, stated that to inform a person of the mandatory parole provision is controlling law in District 2, but not in District 1. Which, at that point, Judge Robert Ware threw out everybody's 5th and 14th Amendments to the U.S. Constitution on that day in Delaware Superior Court, which I have been trying to get the transcripts for over a year now to do my appeal to the state Supreme Court the right way, which I can't get the transcripts, and I'm still being persecuted for the above offense from 1987 on a 16-month sentence. And so my position right now is I'm going to go talk to Melvin Link with the Department of Justice, the Attorney General's office, and bring this to his attention. And if this don't work, hopefully I can get someone in the ACLU to help me out, because since they don't have to tell people about a mandatory parole provision on the time of sentencing or at the time we make it a plea bargain in Superior Court of Delaware County, this county feels that they do not have to tell anybody about the sentence. And if you do take a suspended sentence on probation and you violate that probation, they do not tell you that you will have to serve your prison time and get no credit for the probation time that you put in on this sentence, and you will have an additional 3 to 4 years to do after your sentence is complete, which is in total violation of the 5th and 14th Amendments of the U.S. Constitution. And this county does this with everybody. So it isn't just me, it's just me that's complaining about it.